All right, so welcome everybody to our June 2024 virtual lunch and learn. And our topic today is we're going to go over the family court hearing process and like the overview, because it can be really complicated, right? Family court is a little bit different than some of the other courthouses and things that different types of court hearings that we have. So we're going to get right into it, and we can ask questions. I'll ask kind of everybody. I'll pause a little bit here and there and ask if there's some questions. So feel free to use the chat box or unmute yourself. So here's our child welfare chart. This is Delaware specific, though a lot of other states are pretty similar. But we've got our preliminary protective hearing, adjudicatory hearing, dispositional hearing, review hearing, permanency planning committee, and permanency hearing. So I'm going to kind of go through in detail what each of these court hearings are, the purpose they serve, and what your role as the CASA is. It might change a little bit depending on the court hearing, but for the most part, there are some pretty standard actions and sort of expectations we have for CASAs in order to prepare for these court hearings as well as participate in them. So, two things just to kind of note is that the purpose of all of these court hearings is to look out for the best interest of the child. This is child welfare. So, what is best for that child? And then we're looking at reasonable efforts, which means DFS, as the custodian of a child or children, is responsible for providing reasonable efforts to reunify with the family. So DFS has that obligation or that burden to provide services. Doesn't mean they have to make the parents go, because that's sort of all classic leading the horse to water. But they can't make them drink. So their role is to provide those services in order to support reunification with family. So for the most part today, we do have other permanency options, but we're going to kind of focus mostly on reunification since that is our primary permanency plan. And in 2023, we reunified about 46% of our cases. So almost half. And our goal is to continue that increase and reunify as much as possible because through lots of evidence-based practice and research, we know that children generally fare better when raised by their family. So looking at child welfare, we want to try to support the family to make some changes and adjustments in order to become safer and healthier parents. So let's look at this preliminary protective hearing known as the PPH. So what happens is the Division of Family Services files an ex parte petition, which means, Judge, we need emergency custody of this child or these children based on these facts. As you've taken a case, you will have reviewed the DFS ex parte petition, which gives us an idea of why the Division of Family Services is asking for custody. Those things might be something focused on parental substance abuse, maybe untreated mental health, maybe domestic violence, maybe parenting practices, homelessness, unemployment, maybe a slew or a variety of those things. So DFS says, hey, Judge, this is why we need temporary custody of these children. But they also have to say, here are our efforts that we took to try to find an alternative placement. We interviewed mom and dad. They gave us the names of a few people, but those people did not pan out. Or they don't have any support system, so there's nowhere else for this child to go. Therefore, we need to take custody of that child. So between the ex parte order and the preliminary protective hearing, there's a 10-day span, 10 calendar days that the court has to schedule their next court hearing. So this preliminary protective hearing takes place 10 days after the ex parte order has been granted by a judge. In some of our cases, our CASAs are not yet appointed during the preliminary protective hearing. Why do we do that? Most of the reason is because during the preliminary protective hearing, we basically gather more information to determine whether that child is going to stay in state custody or not. Sometimes during that 10-day period, maybe a relative does come forward or Sometimes there's a misunderstanding between Division of Family Services and a biological family. So sometimes that child does exit or go back home. Also, sometimes a judge can determine that probable cause does not exist. There's not enough evidence to justify removing this child and taking the child into state custody. So the judge will say, "Nope, I am denying, the order of the ex parte order, and the child is going back home." So sometimes we wait to appoint a CASA until after the preliminary protective hearing so that we can ensure that this case is most likely going to stay with the Division of Family Services. So you might come in right after this particular court hearing, but I want you to know what happens during the court hearing anyway. So during this court hearing, the judge determines whether there's probable cause exists that this child, if they stayed with their parents or their caretaker, would be in continued actual physical, mental, or emotional danger, and that there is a substantial imminent risk thereof, which means if this child was not removed, something dangerous would happen. Um, and the judge will determine whether continuation of placement of that child in the home is contrary to the welfare of that child. So, by making this determination, the judge determines whether probable cause exists. So, oh my goodness, what is probable cause? Probable cause means that the judge believes that more likely than not, so roughly, if we're going to put a number on it, let's say 51% likely believes that some of these issues that have caused the child to be at risk. If the judge determines that probable cause exists, the child stays in the custody of Division of Family Services, and we move on to our adjudicatory hearing. If they determine that probable cause does not exist, then the child will go back home or be placed with another family member or somebody who has determined somebody who has been determined to be appropriate. Joyce Rawlings, I believe you have a question. Feel free to unmute yourself and ask your question.
Yes, is it during
Thank
this
you.
PPH phase that that DFS will try to do a safety plan
Yeah,
with the
that's a great
family? Is that
question. Absolutely, that's a great question, Joyce. They certainly could. So here's just a kind of a general example. What if child comes into state custody? Mom and dad had initially struggled in finding people that would step forward to take the child. Child comes into state custody temporarily, but then maybe after a couple of days, they're able to get in touch with grandma, and maybe grandma says, okay, all right, I'll take the child. So then the child will go be with grandma, but there will likely be a safety plan in place that would lay out sort of the restrictions or ground rules of what's going to happen in order to keep this child safe. So, for example, it might say the parents are not to have any unsupervised contact with the child. That means that grandma sort of provides supervision or, something else. But for the most part, that safety agreement, and Joyce, I'm really glad you asked that question, lays out that the child can go back home, but here's our parameters. Otherwise, we kind of be right back where we started and what caused the child to possibly come into care in the first place. Good, thank you. So prior to the preliminary protective hearing, the coordinator will get as much information as possible. Maybe definitely a copy of the ex parte and the petition. They might be able to determine the placement of the child, hopefully foster parent contact information, as well as school information. If you are appointed by this particular time, we would ask that you attend. Now, granted, this preliminary protective hearing only has 10 days to be scheduled, so it is the shortest period of time between court hearings. We also, if you are appointed, want you to identify any immediate needs of the child that need to be addressed at the court hearing, as well as identify records that need to be requested. Maybe the petition determined that parents are using illegal substances. So but they're involved in treatment. So let's get a copy of their urine drug screen. Maybe it was a domestic violence incident. So maybe we want to get a copy of the police report. So we want to try to identify what records we need, even if we don't have them by this period of time. After the preliminary protective hearing, we want to make sure that we know where the child is placed, what school they're going to, or daycare, depending on their age, as well as contact information for the parties. So if we are in person for the preliminary protective hearing and you happen to be there, you can certainly introduce yourself to everyone, especially the Division of Family Services social worker. Identify what contact information you want to share, whether it's your cell phone number or an email address. what is the best way for you to communicate with each party? If it's virtual, we can figure out how best for you to communicate with each individual person. While on Zoom, we would ask if you do attend that court hearing that you change your name, if possible, to say, Joyce Rawlings slash CASA volunteer, whoever whatever your name is slash your role. So one benefit to virtual court hearings is that most people will have that done. They will add their role to their name, which really helps figure out who everybody is and what role everybody plays. Finally, if there's a question about paternity, we want to ensure that there's a plan in place to have paternity tested to identify the potential father or fathers and follow that process. So the court will set up will do the scheduling of setting up a paternity test. You, as the CASA, just like with everything else, you're not providing the service. We just want you to follow up to make sure that it has been done. Any questions about preliminary protective hearing so far?
Yeah, I have a question.
Yep.
When usually the PPH is virtual, or they usually hold them in the court? Is that, I mean,
Usually they're virtual. Yeah, usually
okay,
they're virtual.
okay.
Every now and then, I don't want to say they are all something or never something, because there's of course always, the one that's a little bit different. So, but most of the time it's virtual.
And the parties at the PPH again, who are all the parties again?
Great question. So legal parties would be both parents, one or both parents or all parents. Sorry, I apologize. Megan did let me know that Sussex tends to be more in person. Kent and Newcastle are virtual. But in terms of parties, we've got all the biological parents, as we may have multiple, as well as Division of Family Services, because they are the ones that hold custody of the child. Then if you are appointed, you are a party to the case, as is your child attorney, since they are you through the triad with your CASA coordinator are the ones that provide the legal representation. And then the child, of course, the child is a legal party as well. But at the preliminary protective hearing, you may have witnesses. You might have a police officer. You might have a substance abuse provider. You might have a landlord, for example. Those folks are not parties to a case, but they are just witnesses.
And then also, do you have the for the DFS side, it's like the investigatory workers usually, not a person. I mean, because we get the case from our coordinator, and we usually look at the ex parte motion, and we get documents and stuff like that. But the worker that we're really basically working with is the investigatory worker from DFS.
Yeah, at this point, usually, however, it might be the treatment worker. Sometimes a treatment worker works on a case prior to taking custody, and then once they take custody, they might stay on the case. But I would estimate, I don't know, maybe 75% of the time or so, we are working at this stage with the investigative worker, because they have not yet passed it on to the treatment worker.
Okay.
Yeah, good. Thanks. Good questions. All right. So then we get to the adjudicatory hearing, which is roughly 30 days after the preliminary protective hearing. So if the judge will determine one of two things. One, is the judge dependent, neglected, or abused by the preponderance of the evidence, which means that burden is a little bit higher than probable cause. Probable cause means there's a good likelihood probably this happened. Preponderance of the evidence means now we have evidence that the judge will actually consider. So if we're putting a number on it, let's say they believe it's 75% likely that the child is dependent, neglected, or abused in that caregiver's care. So they can determine whether the child is not dependent and then rescind custody back to the parents. Or, as with most of our cases, the judge will determine that the child is dependent, neglected, or abused. And this is when sort of that ASFA timeline, which is the Adoption and Safe Families Act, starts. So a family has about 1 year to work on their case plan, starting at the adjudicatory hearing. Why does it start at the adjudicatory hearing? So think about Before the adjudicatory hearing, everything is just believed to be true. So at the adjudicatory hearing is where the word substantiated happens, meaning that there is some evidence, there is some proof, and the judge has determined the child is dependent, neglected, or abused. So therefore, that's when the timeline starts. Prior to that adjudicatory hearing, so thinking between the preliminary protective court hearing and the adjudicatory hearing, by now at some point you would have been appointed, so you are legally connected to this case. So prior to the adjudicatory hearing, we want CASAs to contact the foster parent or the provider to be able to schedule a time to meet with your child, introduce yourself, start making that connection and building the rapport. We want to determine the child's wishes to participate in the court hearing. So roughly age 12-ish is when kids participate in the court hearings. Sometimes they want to and sometimes they don't, but we want to make sure that the child feels welcome if they're of age to participate. If there's a question about whether or not your child should participate, speaking with your triad is the next best step. So that way the three of you can determine what you would like to see happen. We'd want you to interview foster parents and ensure that they are aware of the upcoming court hearing. It's not your job to invite them, but it's certainly sort of common courtesy just to make sure they know when it is and if they plan on attending. It is one of the questions on your court report, so it's helpful to know. We found that over the years, as we've invited foster parents to attend court hearings more often, we get a lot of really helpful information from the foster parents, so we'd like to have them participate if possible. Also interview any current or prior service providers. Maybe the child has a therapist or a special education team or any other provider that might have been working with this child prior to this particular moment. We also want to follow up on any current needs. Does the child have any medical needs? And this is something you'd work on with the Division of Family Services. But maybe they have other needs, like it could be something that seems really small to us, but is really big to the kid. Maybe they forgot something at their home where they came from. Maybe it's just a matter of a Snuggie or a blanket or something that's really important to them. That's a big need for a kid. So let's see if we can secure that. We also want to interview each parent if possible. This could be in person, it could be over the phone. A lot of CASAs do this by FaceTime. That way you get to see the person, but nobody has to travel. Remember, a lot of our parents don't have their own transportation. So think about interviewing the parent. If you choose to interview them in person, you're always welcome to interview them in a public place. Libraries are great places. Think about where public transportation kind of already travels to. And we want to ask about relatives. From day one, we want to cultivate this child's connection. Who are their people? Are there extended family members, significant others, step parents, adult children? And we want to look, always look every month, we're looking for a connection for this child, as we'd rather a child live with a kin, somebody that they are connected to, versus a foster home that may be a stranger's home to them. We also want to request and review any and all records we can. Your CASA coordinator will help you get Division of Family Services records, and we want you to take time to review them and understand kind of why the child came into care. Also, if there are any school, team, or triad meetings pertaining to your child, we want you to attend those, especially if there's a best interest school meeting. Maybe they're discussing changing schools, and that's an example. We also want to try to complete your CASA court report 2 weeks prior to the adjudicatory hearing. I realize this might be really tough because you may not know all the answers, especially when we get to the parental case plans, which are pages 3 and 4 for the parents. We don't have a case plan yet, but what you can do is you can look at the petition and determine, why did the child come into care? We want to make sure that those issues are reflective in a proposed case plan. One thing you can also do when it comes to reviewing relatives is create a family tree. So CASAs who have been through new CASA training in the last several years have worked on family trees when working those example case scenarios. Write out a family tree. A lot of your child attorneys will find that very helpful, and you can absolutely attach that to your court report. And then we want to have our triad meeting between the child attorney and the coordinator if it's needed before this adjudicatory hearing. This gets all three of you on the same page, identifies any testimony that you would like to present or that you want somebody else to present. Ms. Joyce, did you have another question?
Yeah, you mentioned that during this time there's a timeline begins. You said the timeline begins.
Yep.
You're talking about the statutory timeline for the case to be in progress or process?
Right. Yep, absolutely. So it's what holds the Division of Family, it's sort of what holds everybody accountable in order to get this child safely out of foster care. So remember, foster care is supposed to be safe but temporary. We don't want kids growing up in foster care. So from day one, we want to look for relative placement, some other alternative placement. We want to provide services so the family can reunify. We are trying desperately to get this child safely out of care. And that ASFA timeline is what makes us have court hearings every 30 to 90 days. So we can follow up and make sure that basically everybody's doing what they are required to do in order to transition this child safely out of foster care.
Lauren, I have a quick question.
Go for it, Steph.
Yeah, so if there's more than one child, it's 2 children or 3, and they decided foster care is the next best start, do they try to like place the 2 kids in the same place, or do they typically split them up?
Oh, in a perfect world, they would all be together. We never want to split siblings up if at all possible. But I also understand that taking on 3, 4, 5, 6 kids is really difficult. Not only difficult, but you also need logistics. Like a bed, every child needs a bed. Every child needs their own place where they can keep their things. And there's just some houses that just don't have extra space. So Division of Family Services desperately tries to keep a sibling group together, but sometimes at that particular moment, there's no available home that is able to house all of them together. So if that happens, then Division of Family Services has to split up the kids.
I was just thinking in terms of 2 kids, but I guess there's could be multiples of that.
Sometimes we have more. Yeah. I mean,
Yeah. Okay.
Yeah, absolutely. So we try to keep siblings together if possible.
I have one question.
Yeah, go for it, Beverly.
I have a case now where there are 2 children, and one is a 9-year-old and the other one is a newborn. And I know most people prefer newborns, but I do because I didn't really have any experience with the IEP system, which I do now. But anyway, with all that said, we had a real problem because the DFS worker absolutely refused to deal with 2 cases, even though the judge issued 2 different orders, one for me and one for the other CASA. But she won't communicate with us because she said she wants the case assigned to the 2 kids assigned to one CASA. She pretty much got her way.
All right. Well, I'm sorry that happened. Hopefully, yeah, I would just suggest that we work really strongly with the triad, both triads, to try to just work together as best we can.
Well, the way it ended up is the deputy attorney generals are pretty much doing the work.
Okay, gotcha.
I mean, the communication.
Right. All right. So
then somebody has to communicate.
Right. So now we've got our adjudicatory hearing, as you are attending. So that was all the work that we did prior to the adjudicatory hearing. Now we've got the hearing. So what's expected of you? We want you to attend. So I want to stress, and I don't mean to be rude by any means, but your attendance is necessary. You are a legal party to this case. So if you have a scheduling conflict or some issue, communicate with your coordinator as soon as possible to ensure that you are able to attend. Now, I certainly understand people are sick last minute. I mean, there's certainly extenuating circumstances, but if you know you have a trip coming up, or you know you have a medical procedure, or you're caring for someone else, please communicate with your coordinator. The hardest thing to do as a coordinator is not know what's going on with you or your case. So we want to make sure you attend. We also want you to testify regarding your child's best interest or any direct knowledge that you have. Most likely during your pre-hearing triad, you would have hashed out what it is that you're going to say, what the questions are that your child attorney is going to ask. But what we can't do is predict what the other attorneys might ask. So we'll get to testimony in just a bit, but we want you to be prepared to testify about information that you know. We also want to identify potential witnesses and any records we might need, and then questions that you want your child attorney to ask that particular witness. And then, as always, we'll identify immediate needs of the child to be addressed before that next court hearing. in your testimony, as someone says in the chat, it can absolutely make all the difference of the outcome of your case. Judges, the 17 family court judges in Delaware, very, very much value and care about, the CASA and their opinion. You have a role, you have a very unique role because you have an unbiased, objective perspective. So then once the adjudicatory hearing is over, we want you to gather any additional contact information. Maybe they've changed foster homes, maybe there's an additional provider. We also want you to identify potential elements that should be on a parental case plan. So remember, going back to the ex parte order, identifying reasons why the child came into care so that when we get to the next court hearing and you receive a copy of the DFS proposed case plan, you can sort of compare left and right, yours and theirs, to make sure that they're equal. Do you have something on your case plan, proposed case plan, that DFS doesn't have? Can we ask them to add it? Does it make sense to add it? Or does Division of Family Services have something on the case plan that you think may just not be necessary? Maybe it's just an added step for the parents. That's where we would kind of hash that out, and that's what we do at the next court hearing. So this hearing is the forum for us to bring any issues we have, about our child client. So then we get to the dispositional court hearing. So this is 30 days after the adjudicatory hearing. By now, we receive our case plan. In a perfect world, we would receive the case plan before the adjudicatory hearing. But sometimes we receive it either a day or two before or at the dispositional court hearing, which to me is why it makes sense for you to have an idea of what you want on there so that when you receive the proposed Division of Family Services case plan, you can kind of quickly go through and say, yep, that's what I have. Yep, that's what I have. Yep, sounds good. Or say, some things on there that we don't agree with. This court hearing will indicate what is expected of the parents and what services are to be provided to them so that they can fulfill those expectations. At the end of the dispositional hearing, we want to make sure that every party to the case knows exactly what is expected of parents in order to have custody rescinded back to them. So we want to make sure there's no questions. And then at this court hearing, we identify any elements that you believe should be on this case plan. And the judge will determine if reasonable efforts towards reunification have been made in this case plan, which means this case plan accurately reflects the needs of the parent. One thing CASAs can play a pivotal role in is really supporting the parents and understanding that a case plan is meant for their benefit and assistance. It's not meant to penalize or jeopardize any relationship with their child. It is meant to help them. So the more we can encourage them to pursue the efforts, to take part in that case plan, the better off they'll be in terms of not only getting custody rescinded back to them, but also being more healthy and safer parents. Prior to this dispositional hearing, so this is that 30 days between the adjudicatory hearing and the dispositional hearing, definitely want to make sure you meet and interview your child again. Remember, a requirement of being a CASA is that you meet at least once a month in person with your child. We also want to determine their wishes. Infants are a little harder because they can't verbalize their wishes, but any child that is of speaking age, ask that question, ask it every time and ask it in a variety of ways, because it's part of those best interest elements and the factors that go into a judge determining what is best for this child. Just like in the last court hearing, we want to interview foster parents, let them know of the upcoming court hearing, receive the reunification case plan, receive and provide any updates of providers, anything about the child's history that we want to follow up on. We also want to make sure we know where the child is placed, their current school, the visitation schedule, any services that the child might need. So we want to make sure that we have all these things. If possible, we want to interview the parents in the variety of ways we mentioned last time. Request and review any records. Maybe by now we would have school records. Maybe we have medical records. We want to request and review those. Also attend any school, team, or other meetings pertaining to that child. By now, we should be able to write our court report. Again, it's before the case plan has been adopted, but what you can do on page 3 and 4 for both parents is say what you would like that case plan to say. Do they need mental health services? Do they need substance abuse services? Do they need parenting classes? Then we also want you to participate in that pre-hearing, we still call it, maybe call it a teleconference, but that triad meeting. So that we have a question in the chat about the adjudicatory hearing and the dispositional hearing. So the difference, but other than being 30 days apart, so at the adjudicatory hearing, the judge is able to receive more evidence, police reports, records, photos, photos of the house, photos of any physical abuse, any actual evidence in order to determine that the child should stay in DFS custody. Then with the dispositional, so at the adjudicatory, if the judge says, yes, these things exist, the dispositional then is that case plan. So think about it where the adjudicatory is the yes or no, did it happen? Is there, is there preponderance of the evidence that these things are present? And when the answer is yes, then 30 days later, that dispositional it sets us up for the treatment. So think about maybe adjudicatory hearing is listing of symptoms and dispositional is list of treatments. I don't know if that makes any sense, but it's sort of the treating the issues that brought the child into care in the first place, which is what we determined during that adjudicatory hearing. So I hope that answers that question. Then we've got what's expected of you. Attend, please attend. Testify about anything that you want to testify about or that you have direct information about. Remember, you might have a different opinion or a different observation than someone else. You might have received different information from another resource. So we want to make sure that you testify about what you directly know. Read those records, address any needs of the child, and then schedule your pre-hearing, your triad for the next review hearing. A lot of times your coordinator will get that all set up, but we want to make sure that we know ahead of time when it is. And then after the dispositional hearing, we want to make sure that we communicate with everybody involved in this case about the case plan. Make sure your family understands the services that they need to participate in. But if you think something is missing, always ask your coordinator. But we want to make sure that once we all leave the dispositional hearing, we sort of have our marching orders and we know what is next. Remember, I'll say, does anybody have any questions about the dispositional court hearing? So I don't know if this is helpful or not, but I think about preliminary protective, adjudicatory hearing, dispositional hearing, PAD. And I don't know why this makes sense in my head, but I think about a big, like a big trampoline type pad, a big foam pad that is here to support the family. So that's how I remember what order they go in. This will either totally mess you up or maybe you'll remember it because it's kind of odd, but I remember P, preliminary hearing, preliminary protective hearing, A, adjudicatory hearing, D, dispositional pad. We are supporting this family. Remember, you are an independent investigator. You do not need to agree with DFS all the time, but you don't need to oppose them all the time. You don't need to support the parents' wishes all the time. You are independent. With that said, though, we don't want to rely solely on what other people tell us. So, for example, if you have a child in a foster parent's home, we want you to see that child. Remember, you need to see them at least once a month. We don't want you to call up the foster parents and ask how the child is doing and consider that your visit. That is not a visit. You are independent. You have your own thoughts, your own opinions, and your own life experiences. Somebody may look at the same exact situation as you and have a totally different observation and opinion about what's happening. We have you. You are such a strong voice for that child with an unobstructed, very objective perspective about what's happening in this case. So while we want to rely on some information from others, we also want to do our own action. So another example would be if a parent, you're checking in with the parent and substance abuse is on their case plan, maybe you check in with them and ask them how they're doing on their substance abuse treatment. Maybe they tell you, great, they've been sober for 2 months and everything is going well. While we would love to believe them and hope that that's absolutely true, we want to double check. We are an independent investigator, so we're going to ask for a urine drug screen from their provider so that we can hopefully verify that what they're saying is exactly true. Ms. Joyce, do you have another question?
I just had a comment. In terms of being an independent investigator, a lot of times I find that it's hard for the foster parents and the other people that are involved, even the parent, to see you as independent, because if you're asking for documents, like you may ask for a release of information form, you need them to sign that. They think, oh, well, we've already provided to DFS, and why do we need to provide it to you? And in terms of even just keeping a schedule of the visits for the children and doctor visits and things, it's like, well, we're giving all that information to DFS, and they
Right.
feel like it's DFS's responsibility to give it to us. And I keep on stressing we're independent, and it's not DFS's responsibility to provide me with information, that I'm just simply trying to get the information from you so that I can have it independently. So
Right.
that
You're
I
absolutely
mean,
right.
because that's hard in a sense, because really it's like, almost like we have no allegiance to you.
Right,
It's
right.
the DFS that they really like. Well, they the ones that have the children. So I find it a little hard to get information, to coordinate, and even just remind them, I need this information. And it's a reason why I'm trying to get this information. I have your best interest for your children in mind. And yes, my decision, the recommendation can be different than DFS. So I need this material for myself,
Right. And
to be able to prepare my report, be able to give, if the judge asks me or I get to testify, I have my own independent information.
absolutely. Yeah. You're right. That's a tough situation sometimes, but yes, we're separate from Division of Family Services. So yeah, you're right, Joyce. Thank you. So then after the dispositional court hearing, we come back every 90 days. And remember, as an appointed party, you are part of the scheduling about when that court hearing will be next. So we know 90 days later, after the dispositional court hearing, we have those review hearings. So these are held every 3 months, focusing on the safety of the child. The court will look for the needs and appropriateness of the child's placement. They'll look at the extent of compliance with the case plan by the parents, which means between the dispositional court hearing and the first review hearing, have the parents made any progress in their case plan? If so, what is that progress? What does it look like? Are we moving towards alleviating, the need to have removed the child from the home? Are the issues that brought the child into care no longer, or at least not as much an issue, as before? We also look at the projected date of safe return for the child, which, is in sort of that within that 1 year time frame, or are we starting to look towards another option? But this is our first judicial review hearing, let's say first, and then we identify long-term goals. So depending on when your court hearings fall, you might have two or three, maybe 4 review court hearings, and it's all to review the progress of a case plan from the parents. Sometimes if a parent is working on a case plan and they're almost done, maybe they have 1 or 2 elements left, most of the family court judges will allow them additional time, maybe 3 months, to work on finish that case plan. So for example, housing is really difficult. Affordable housing is almost an oxymoron. Just out of curiosity, I just Googled all 3 counties for rent, just a decent rental unit with 2 bedrooms. And I really struggle to find anything less than two grand a month. So maybe they're struggling with housing. That's not really something that's in their control, other than just continuing to look for housing. But a judge isn't going to penalize them for not having housing if they've done everything else. So that would be an example of where a judge would provide them, most likely, some additional time to secure that housing. Prior to each review hearing, we want to make sure that you continue to meet and interview your child, determine the child's wishes to participate, chat with and remind foster parents about the upcoming hearing, receive any current or prior service providers or upcoming providers, anything. We want to follow up on the needs of the child, interview each parent, review records, identify what witnesses we want to testify. Sometimes, we want maybe a service provider to testify directly about the service that they have provided and how is it going. By now, we definitely want you to complete your court report 2 weeks prior to the court hearing. It should be as complete as possible. with a court report, we don't want to leave any space blank. As if I'm a coordinator and I see a blank space, I'm assuming that we don't know that answer, so we need to follow up. Maybe that's not true. Remember, if something doesn't apply, just write NA in each of those sections, not applicable. So we want your court report to be as full as possible. And someone asked, does it apply to employment as well? Yeah, that's a good point, because in terms of having an employment, somebody not having completed everything else on their case plan except employment, the parent would most likely just need to demonstrate that they have tried to apply for employment opportunities. Where have they interviewed? Where have they put in their application? Maybe they're waiting to hear back from places. So, London had that good question. Just very similar to housing. As long as they're showing that they are actively trying to secure housing or employment, most judges will give them more time in order to secure that thing, as long as other elements on the case plan have been completed.
Lauren, can I ask a follow-up question to that?
Yeah,
Sorry.
go for it. No, please do.
So I know that you said judges will typically extend that time period, which I have experienced, for specifically for employment if everything else is met. Is there a cutoff time? Like how many 3 months do they get for that?
That's such a good question. And my answer is going to be it's dependent on the judge.
Okay.
Yeah. Sorry that I don't have a better answer. It's really going to depend, because the other side of that is at some point the case needs to end. And does the child stay in foster care for a lengthy period of time, waiting the parent to secure employment? Like at some point, and I don't know what that some point is.
Okay, thank you.
Yeah, great question. So we have these review hearings. We definitely want you to attend. These are not optional. We want you to testify about your child's interests and then immediate needs of the child, request records, all the same things we've done for the other court hearings. And after the court hearing, we want to get an idea of what else is left on the parental case plan. Are we pretty close? Or are we not close at all? Are there any gaps in services, anything that needs to be fulfilled? And then what is the likelihood of the case being completed? Then we will have the Permanency Planning Committee, which I'll explain in just a minute, scheduled relatively quickly. And that's usually held around the 9-month mark. So once we've had two-ish or maybe even 3 reviews, we might have this Permanency Planning Committee meeting. So what is the Permanency Planning Committee meeting? Known as the PPC. It is an internal DFS review. It is not a court hearing. So what happens is that you will be invited to attend the PPC, and they're held roughly at 9 months. And the purpose is to either change or alter the permanency plan. When I say alter, meaning we can have a concurrent plan, which means we have more than one permanency option. So it might be reunification / termination of parental rights for purposes of adoption, or reunification / guardianship, which means we're working on both of these things. In case reunification doesn't happen, we are ready for the next action. So your coordinator will let you know when this is scheduled. Your DFS worker will provide a case summary. They will ask you, the PPC will ask the CASA to provide input. You are not part of their vote, but they will ask for your input. Once the outcome comes out, which means they determine to continue to reunify, they've added a concurrent plan, or they've changed the plan altogether. Maybe they go from reunification to termination of parental rights for purposes of adoption. Within 30 days, you will work with your child attorney to file a motion, to respond to the motion that has been filed, where you either support the change of the plan or you oppose it. So once the Permanency Planning Committee internally changes their goal, the DFS attorney will file a motion within 30 days to the court to say, we would like to change or alter the permanency plan. You get a chance to respond, and then we have a permanency hearing. At the PPC, you are expected to attend if you can, and then provide input. What are your thoughts? What are your beliefs about the parent being adequately able to complete their case plan? Answer any committee questions. Again, you might have some observations that others might not have, and then state your recommendation. So then the committee deliberates, and then we respond. At the, prior to the permanency, I'll go back to permanency planning committee for a second. If you have more questions or want to know more about the permanency planning committee, we have a recorded training on the YouTube channel about the PPC. It goes into a lot more detail. So if you have more questions about this PPC, definitely check the YouTube channel to find that video as well. I want to leave enough time for questions at the end. So I've got moving on to the permanency hearing. So prior to this permanency hearing, you again do all the things that you're supposed to do between each court hearing. Meet and interview your child, determine whether the child wishes to participate, remind foster parents of the upcoming court hearing, receive updates about any services, follow up on needs of placement, education, visitation. Interview each parent, especially if we're getting to by the permanency hearing. If we are reunifying, we're really close to having that child placed back with the parent. If you have a reunification happen, what generally happens is the Division of Family Services will do a trial home placement. So rather than saying, okay, parent, here's your kid back, and kind of making a quick adjustment, we sort of have a slow process in order to kind of get reacquainted with each other. So for example, it might look like this. The parent is having 2 hours, supervised visits with their kids, once or twice a week. Then we move on to unsupervised visits where they just have, free time, just the family. Then we might go to an all-day visit from maybe 9 a.m. on a Saturday to 6 p.m. on a Saturday. And that may or may not be, it's usually monitored, which means a professional will set up the visit, stay for the first half hour or so, then leave, then come back later or within the visit so they can just kind of monitor, but they're not sitting supervising the whole thing. Then we'll do that for about 2 weeks. Then maybe they go for an overnight. So they'll go from 9 a.m. Saturday to 6 p.m. on Sunday and have one overnight for a couple of weeks. Then they'll go to 2 nights. So Friday night to Sunday night at the parent's home. And by now it's been 6 to 8 weeks or so. By now we're feeling good about the reunification, and it will likely end in reunification at the permanency hearing. Or if something, sadly might go wrong, Division of Family Services still holds custody, so they are able to respond. At the permanency hearing, we want to make sure you complete your CASA court report at least 2 weeks prior to that court hearing and attend your triad meeting to get ready for this court hearing. Question. Okay, yeah, thank you. At this preliminary protective hearing, just like everything else, attend, address the best interest, any immediate needs, state your recommendations for permanency. So remember, at the end of the day, it is your job to have an opinion. We want to know what your recommendation is. So we want to make sure that you state clearly, what do you support and why? And then we want to make sure that after that permanency hearing, that your child's wishes are along with what you believe is in the child's best interest, based on all the facts and evidence and information that you have gathered, that this is what you feel is right. At the end of the day, the judge decides. So even if the judge goes a different way than what you propose, please know in your heart that you did the best you could. You advocated for a particular action and the judge may have felt differently. Most of the time, the judge agrees with CASA. So we'll just, each case is different, but your role is to state your recommendations for permanency and then support it with facts and evidence. Sometimes, though, we don't reunify. So then we go to guardianship or permanent guardianship. These are, very similar to the other court hearings. We want to investigate that potential guardian. If it's a permanent guardian, they would have had a home study completed. We want you to have gone to the guardian's home. What are the logistics of caring for this child? Do they have a space for the child to sleep? Do they have a space for the child to live within that home? What are their plans for taking the child to and from school or daycare or whatever else their needs are? We want to make sure that the guardian or permanent guardian understands the legal criteria and benefits of both or whatever option that they're setting up. And we can also schedule a team meeting with the guardian to determine what are the options. Maybe you have somebody who says, yes, I'm willing to step forward for this child, but they may not know the difference between guardianship, permanent guardianship, or even terminating parental rights for purposes of adoption. That's where your CASA coordinator can really come in. And we might even want to bring in the permanency worker so that they can explain the different options and benefits to the potential guardian so that they can make an educated decision. After the guardianship court hearing, we want to identify, like, yes, is that going to happen? And the knowledge of where this case is going for guardianship. So are we getting close to guardianship or permanent guardianship? Is that a likely option? Any questions about guardianship or permanent guardianship? And if we're confused about any permanency options, we also have another recorded training on our YouTube channel about permanency options, which reviews reunification, guardianship, permanent guardianship, termination of parental rights for purposes of adoption, and APLA, which is another permanent planned living arrangement. So that training goes into those ones in detail. So then we've got post-permanency hearings. Maybe we've changed the plan, but we're not quite ready to go forward with the guardianship or adoption. Same things apply. Keep in touch with your child, identify permanency options, work with the youth to identify potential placements. I love this. I mean, who is better to identify where they want to live than the youth? With that said, they may not identify appropriate placements, but at least working with them and encouraging them to be part of the process can be really, really helpful. We want to make sure the youth's needs are met. And if they're 16 or over, we want to work really closely with the independent living provider to ensure that those independent living services are being provided to that youth 16 and older. And after this permanency hearing, we want to understand the possibility of a placement with any resource. What are our permanency placement options? And then any services available to youth and how will they be provided to them? There are a lot of services out there for 16-plus-year-olds. So we want to make sure that they're connected to them, understand what their options are. We just did a podcast on the program through Division of Family Services called TAY. There's lots of services. So we want to make sure that they are connected to them to the best of their ability. Last little bit before we wrap up here. So our court testimony, tips and tricks. I really want to stress the need to dress appropriately. Please, please do not wear flip-flops, sleeveless tops, t-shirts, jeans, sweats, slippers, anything flashy or revealing. Dress like you are going to court. We want to be taken seriously. We want to align with other professionals in the case. So please, please dress appropriately. For etiquette, we always want to address the judge as Your Honor. And then to prepare, review your court report. You wrote it. You're the one that knows more about your case than anyone. So we want to make sure that you're prepared. And part of that preparation is participating in a your triad meeting prior to your upcoming court hearing. And then during testimony, only answer the question that is being asked. One of the child attorneys says, don't give away the goodies. Wait till you're asked, answer just that question is being asked, but also do not speak unless you're asked a question. This is not a discussion. This is not a meeting. This is a court hearing. So we want to make sure that you as the CASA only speak because you are a witness. We want to make sure that you speak when spoken to, when asked a question. And we want to stick to facts. So we never want to be in a situation where we are making up information. If you don't know, just say, I don't know, or I don't remember, or may I consult my notes or something like that. We never want to just make up information. And if you're stating an opinion and you have evidence, then you can always refer to that evidence. Sometimes that's the best way for a child attorney to get evidence submitted into the court. Usually they'll do it in a variety of different ways, but that's one possibility. So we want to think about what evidence supports what I'm saying. With our court appearance, we want to look like this. We don't necessarily need the suit and tie, but you get the picture. We want to dress like we are professionals. No bathing suits, no slippers, no robes, none of that stuff. We want to be professional and be taken seriously because we are judged by what we look like. So we want to be put together like we are going to a court hearing. That still stems for virtual court hearings. At least get dressed from the waist up, okay? So we want to dress the part, look like we are in court. We want to make sure that we are taken seriously. Think about your surroundings and your location. So we want to make sure we have a private space. Your spouse, who's walking behind you, they would not come to court. So why would they be in your area? We want to make sure that we have appropriate lighting, that we're not looking like a silhouette. We want the court and everybody else on Zoom to be able to see our faces. With that, we turn our video on, but we keep our microphone off until it's our turn to speak. We want to make sure that privacy is really taken at a forefront. It's very important. We want to make sure that children and spouses and animals, nobody's in the background, because again, those folks would not come to court. And we want to behave like we are in a court hearing. We want to make sure that if your cell phone is next to you, it is silented. If there's any other noise or anything happening, we want to make sure that you have limited obligations. With that said, this is a court hearing. It is not appropriate to get up and walk around, leave and go to the bathroom. You're in a court hearing, just like you are. If you were in person, you wouldn't leave the courtroom. So it's a little bit odd sometimes, but treat your computer just like you are in a courtroom. So you cannot just get up whenever you want. You cannot, do the things that you want to be able to do necessarily. Wait for the breaks. And remember, your video is on. People are watching you. We want to be really careful with our facial expressions, our responses. Anything else that's going on, we want to just kind of make sure that we are professional. All right. Anybody have any questions?
Hi, Laura.
Yeah.
Oh,
Right, Anita.
it's Anita. I just a question in general, and in the YouTube videos, would there be something on moving towards, I know we talked about geared this session on moving towards reunification. I'm getting ready to go into TPR and adoption. And so is there anything that I can follow up to see what happens from that process on?
Yeah, actually, and I can email it to you, Anita. There's one about the transition between reunification and the termination of parental rights process through the eyes of a child attorney. And that's a good one. So I will email that to you in just a moment.
Appreciate it.
You got it. That's a good one. Anybody else have any other questions? All right. Well, thank you all so much for attending today. I will go ahead and give you all your hour of training credit. And I thank you for watching.